My name is Jim Turk, and I'd like to welcome you to this session that the Center for Free Expression is presenting today. Before beginning, I'd like to start with acknowledging that the land on which I'm speaking to you today is the home traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many First Nations, Inuit, and Métis. I also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Chippewa bands. On behalf of the Center for Free Expression and our co-sponsors for today's panel, which include the Edmonton Public Library, the Toronto Public Library, the Thunder Bay Public Library, the Milton Public Library, the Vancouver Public Library, and the Whistleblowing International Network, we're pleased to welcome you to the virtual forum series panel, Does Confidentiality Work Against Justice? Non-disclosure agreements, or NDAs, and other confidentiality agreements are increasingly common and increasingly controversial. Seen by many as necessary to make resolution of difficult disputes possible, NDAs and other confidentiality agreements often prevent the public from having access to important information and can perpetuate injustice. We have a remarkable panel today to explore the issues with confidentiality agreements and suggest ways forward. I'd like to introduce the panelists now. The first is Julie Mcfarlane. Julie is director of the National Self-Represented Litigants Project and Emerita Distinguished University Professor of Law at the University of Windsor. She has written on the legal system and the role of lawyers and on misperceptions of and prejudice toward Muslim communities in North America. Her newest book is entitled Going Public, A Survivor's Journey from Grief to Action. It describes her personal experiences of sexual violence, her efforts to use the legal system for change, and her firsthand experiences of institutional cultures, churches, schools, and universities that tolerate and suppress sexual violence. Julie is a member of the Order of Canada and has been named as one of Canada's 25 most influential lawyers, among many other honors. Welcome, Julie.
Very nice to be here. Thank you.
Our second panelist is Dan Michaluk. Dan is a cybersecurity, privacy, and information management lawyer and partner at the law firm BLG. He has represented clients in significant privacy, security, and freedom of information litigation, including at the Ontario Court of Appeal and the Supreme Court of Canada. As part of his practice, Dan frequently advances organizational confidentiality claims in freedom of information matters and data recovery litigation. He is also a regular advisor to educational institutions on sexual violence matters, work that often involves a careful balancing of interests relating to confidentiality and free expression. Welcome, Dan.
Thanks, Jim. Nice to be here.
Our third panelist is Ifeoma Ozoma. Ifeoma is a partner and as founder and a principal of Earthseed, a consulting firm dealing with issues of tech accountability, health misinformation, and other public policy. She is a tech policy expert with experience leading global public policy partnerships and US federal, state, and international policymaker engagement at Pinterest, Facebook, and Google. Ifeoma's health misinformation initiatives have been lauded by the World Health Organization, the Washington Post editorial board, and the New York Times. She is a member of the Brookings Institution's Transatlantic Working Group on Disinformation and is a member of the Washington Post Technology 202 Network. She has played a lead role in California state legislation to allow every individual in California to share information about discrimination that they have faced on the job, even after signing a non-disclosure agreement. Welcome, Ifeoma. Our final panelist is Emma Phillips. Emma is a partner at Goldblatt Partners, where she practices in the area of labor and human rights law, particularly in the university sector. She has extensive experience in assessing the systematic roots of workplace harassment and sexual misconduct. Emma acted as legal counsel to former Supreme Court of Canada Justice Marie Deschamps in the external review of sexual misconduct and sexual harassment in the Canadian Armed Forces, and was legal counsel to the Civilian Review Complaints Commission on its public interest investigation into harassment and sexual harassment in the Royal Canadian Mounted Police. Emma regularly acts as an independent workplace investigator and teaches and conducts harassment and discrimination prevention training and implicit bias training. Welcome, Emma.
Thanks very much.
And our moderator for this great panel is Anna Myers. Anna is Executive Director of the Whistleblowing International Network, or WIN, the global network of whistleblower protection organizations from 33 countries. The Center for Free Expression is pleased to be the Canadian member of WIN. Anna is a United Kingdom lawyer, although she was originally trained and called to the bar in Canada. She has advised hundreds of individuals on their whistleblowing concerns in senior roles in the major whistleblower protection organizations in both the United Kingdom and the United States. She has trained senior executives and policymakers in the public and private sectors on embedding sensible whistleblowing arrangements to support open and accountable workplaces and to protect society, and has advised numerous governments on whistleblowing law and practice. She has been an advisor on whistleblowing matters for the United Nations, the Organization of Economic Cooperation and Development, and the Council of Europe. Welcome, Anna.
Thank you.
Now, the format for today's panel is that the panel is going to have a conversation about these issues for about 45 to 55 minutes, at which time they will turn to questions and answers from the audience. So I'd like to encourage any of you who are listening to the panel, if a question comes to mind at any time during their conversation, look down at the bottom of your screen, you'll see a Q&A button. The chat function is disabled in this version of Zoom, but there's a Q&A button. Click on that and simply write out your question when it comes to mind. You don't have to wait till we get to that part of the program where we turn to the audience. Just to enter your question as you think about it, and then the questions will be dealt with when Anna and the panel turn to the audience. I think that's it. Over to you.
Thank you very much, Jim. Well, I'm so delighted to be here and to be actually part of this moderated discussion with these incredible panelists, because we are really going to be discussing something that is challenging the legal community, but also is really catching, I think, the imagination and the notice of large areas of the public as well. And I would like to just sort of perhaps take a couple of minutes to contextualize this discussion. And what we really are focusing on is the very real problems that confidentiality clauses in employment agreements of all sorts, and not just employment agreements, but we are focusing more on that at this point, have caused in protecting the public interest and the public's right to know. And as Jim said, particularly in cases of sexual harassment, racial discrimination, and sexual and gender-related discrimination. I think one of the things I just wanted to talk about very briefly is that there has been this kind of a public awareness now, and it comes from major movements really in the Black Lives Matter movement, as well as the Me Too revelations. And they've really started to discuss what confidentiality clauses can do by failing to perhaps warn of illegal behavior, and I think has perhaps reconnected some of what gets treated in employment contexts as individual disputes between individual employees and their employers, but actually is raising systematic and systemic issues. One of the things that really struck me as the Me Too revolutions started to come forward is that as a woman, it really did occur to me that in lots of workplaces, and particularly as a younger woman, we were aware of those we worked with who were sexual harassers, and we would quietly inform each other to, just stay away from him. Don't make sure you're not in a quiet room. Make sure your other people are around, or just be aware. And I think it repositions some of what has been taught to us in some ways, that these are individualized bad apple situations, and yet perhaps these are systemic problems. And so again, these are just some of the shifts in public awareness of some of these issues. And I think the individualized nature of some of these agreements that we're talking about can belie the public interest issues at stake. And it's vital that we understand how we can both protect an employee without harming the public interest. And obviously, the employer is very much part of this discussion. I also just want to remind people that none of this is new. For example, in my area of expertise, which is whistleblower protection, laws as early as 1998 made gagging clauses null and void when it came to public interest disclosures. And that could be in any agreement to do with sort of what I call prenuptial agreements, entering a job, and with severance agreements or mediated agreements. And in newer laws, like the European Directive on Whistleblower Protection, the right to disclose cannot be waived or limited by any agreement when it comes to the public interest. So you can see that things are starting to change in that area. And I really wanted to perhaps start with just asking Ifeoma, as the non-lawyer here, and also then to talk a bit to Julie, who are both really starting to challenge this area and are pushing beyond even and helping me to understand some of the issues that are being challenged and reconceptualizing some of this. And perhaps, Ifeoma, if you wouldn't mind just starting. You have expertise, you have experience yourself with NDAs or the non-disclosure confidentiality issues, and you've also taken all of that together and are working on a reform project. So it'd be great to hear from you.
Thank you so much, Anna. As you mentioned, I have my own experience signing NDAs, both at the start of employment for all three companies that I've worked for, and then at the end of employment, in particular with Pinterest. And I've spoken publicly extensively about my experience at Pinterest, so I won't go into the details here on that. But part of the agreement and part of the issue with the agreement that I was presented when I left Pinterest or was forced out of Pinterest after raising discrimination and retaliation claims, both at Pinterest and with the state of California, was that they precluded me from speaking about anything. I was someone who was fortunate enough to have an attorney through the entire process. We engaged in mediation with the company, and yet I was still presented with an agreement that in many ways was very similar to the language that we saw through the Me Too revelations that Harvey Weinstein and the Weinstein Company forced folks to sign. And so I've taken my public policy experience and the work that I've done working at the state level and federal level with legislators to work now on a bill called the Silence No More Act in California that would bar the use of non-disparagement and non-disclosure agreements in situations of discrimination, harassment, or assault in the workplace and in housing situations. The focus of this conversation is, of course, the workplace, but it's important to know, at least in the United States, often landlords use NDAs, both the disparagement and the disclosure agreements, in agreements with their tenants too. So there are very few protections for individuals here in the United States, but it's especially egregious because we don't have any at the federal level that address NDAs in general. And then state by state, what's considered discrimination or harassment in the workplace differs. So unfortunately, instead of addressing the entire country, we're forced to address it in a state by state, 50 state manner. And so this bill right now, I'm really excited. We just got news, and it was just confirmed right before we started, that we're moving on to a full Senate vote in the California legislature. And my hope is that it serves as a model for other states and then for a federal bill eventually when our Congress gets its stuff together.
Great. I mean, what's so fascinating, and the reason I thought it was really important to start with Ifeoma and Julie really is that you're ahead of the curve, right? So I was having an interesting, Em and I joined far too early this afternoon, and we were having an interesting conversation about just the law, and as lawyers, and there's probably a few lawyers in the audience. Law is, you get to the courts, for instance, when it's gone wrong. And courts aren't the fastest moving beasts. They're not the most radical institutions. And they are, as they say, balancing and looking back as well as looking forward. So you're pushing, both of you are ahead in so many ways. And so you're challenging some of my notions that I was taught through many years of through both just I think formal education, but in law school in particular. And whistleblowers have taught me a lot over the years about some of the norms, or what you almost could call, we wouldn't call it that in law, but industry-wide practice. What becomes normalized. And I'd be interested, Julie, from your point of view as an academic, and then obviously watching the space of lawyers and how they operate and how to support represented litigants. How much is this about changing legal perceptions of what is normal? And that's sort of, we're already in a room with walls that are painted, and we're not necessarily changing the discussion we need to have with our clients if they're employees, or perhaps, and maybe we are having to change them a bit more with the employer side. But what are the norms that we're kind of starting with that maybe we need to challenge? And perhaps you could link a little bit of that to your vast experience, but also, again, you're taking on not just the work that you've done in legal education and for self-represented litigants, but you're actually working with another government too that is looking at NDAs. So this is an amazing time to be having this discussion. So Julie, I'd really like to hear what you think.
Thank you very much, Anna, and thank you, Ifeoma. It's great to be on this panel with you. It's interesting, Anna, you talk about me as an academic in this area. This was an accident for me. There are many other things that I've done in my academic work that I have, sought to become an expert on, but this, in relation to NDAs, was a complete accident. I stumbled across the practice of NDAs 3 years ago when a former colleague of mine at the University of Windsor Law School was eventually terminated by the university after many years of sexual harassment and other misconduct. From his letter of termination, it included intimidation, abuse of power, and pushing the boundaries of professionalism with students. And at the time, I had been the person that many of these students had come to, and we had been pressing the university to do something about this for a long time. And when he left, he made a settlement agreement, which of course I would expect under these circumstances. But what I didn't expect, I was very naive then, was that they would have given him a non-disclosure agreement. So I only realized that the university, and I should say, I'm calling out the University of Windsor, this is all universities who do this. I only realized they'd given him an NDA when I started to get calls from colleagues at other law schools to whom he'd applied for a job, asking, why would a tenured professor just up and leave? And of course, I told them the truth. Now, bear in mind, I'm not a party to the NDA. I would never sign an NDA. In my own litigation for historic sexual abuse against the Anglican Church, when I was the plaintiff, I said right at the very beginning, I'm not signing an NDA, don't even try and ask me. So that didn't come up. But in this case, I found myself telling the truth and then being sued for defamation because my employer of 25 years decided that they would hide the documents and refuse to defend me. So I can talk more about this later, Anna, but the consequence was that I now have a defamation order against me in Trinidad, and the university documents, which I now finally have, obviously show that everything I said was truthful, but the university wouldn't produce them. So I think that we need to start to think about exactly what you said, Anna, which is that there is a really prevalent culture. And, I have to say, I was naive. Even in places like universities, which I have always thought for the last 40 years were places of high principle, there is a culture that makes many, many employers and many, many members of the legal profession complicit in seeing NDAs as a default in the bargaining process. I imagine that it really, doesn't take me to point out to everybody here that we know almost all cases settle before litigation. That was why the university settled with my former colleague. But they settle in all kinds of different ways. And as an employment mediator for many, many years, they can settle in all kinds of different ways. And that depends upon the creativity and the commitment, I think, of the negotiators to really find good solutions. And one of the things I really want to talk about today, Anna, and try to remove some of the myth around NDAs that I have now heard continuously since I started doing this work, speaking up about the need to stop this, is that NDAs are about the victims, that they're there to protect people who always and in every circumstance would die a million deaths if there wasn't confidentiality. And there are so many myths associated with that. First of all, not all victims do actually want confidentiality, but their lawyers certainly assume that they do. But I think that we need to refocus the fact that the benefit of an NDA is primarily for a perpetrator and or an employer. Because in this case, a perpetrator and an employer, in my case, the university and my former colleague, they have identical interests. And exactly the same was true with the NDAs that Ifeoma signed. It becomes, the person who is committing the misconduct, who is harassing, who is discriminating, who is being a racist, who is being a bully in the workplace, they want this to be hidden because they want to move on and go to another job, just like my former colleague. And their employers actually want it hidden too, because for something like this to come out, which almost inevitably establishes that the employer has received complaints about this individual for many years, but they've done nothing about them, makes the employer look bad too. So we hear a lot of language about how this is all about protecting victims. And I think that as someone who has been a victim of sexual violence and now has become a third-party casualty of an NDA, I think we have to really clarify that. I think that one of the much more central issues that we have to address, as you said, Anna, is that NDAs actually create more victims because they allow people to move on, as my former colleague did, to another school full of young women. And that, I think, is what we really need to be talking about here, are all the other potential victims. And if you like, the public interest is the victim. The public interest is not being protected by hiding people's misconduct and their risk to others.
Great. Thank you very much for positioning and putting some things on the table. Emma, I was going to move over to Emma because I think one of the things that's really interesting, and this is where I'm getting my head around it, so I hope that my bafflement and trying to get through all of this is helpful to the audience. They may be ahead of me on this, but in my work with whistleblowing, classically understood, people are speaking up about the interests of others often. It's about corruption that affects service users or a bridge falling down or environmental safety, and it's kind of, yes, there and a lot of the discussion is who's responsible, and the employer gets to it can be diffuse, that responsibility, or occasionally it can be one person, which they but often I think it is an issue of accountability and responsibility, but it's kind of vague, the third party in the room. What Ifeoma and what Julie are talking about is there can be specific, well, and especially in Julie's case, and Ifeoma can correct me if I'm wrong, but there can be specific perpetrators of the harassment, but also there's discrimination in the employment practices that Ifeoma is talking about. So that is more the employer. The third party, where there is somebody, what is this issue around, whose interests are at stake, and how do we start to unpick that so that we're not, we are separating some of those out. And so we do perhaps challenge if there is a third person involved and the employer seeing that they have to protect the public interest too. So Emma, you've done some of this work as well in your labor and human rights practice, working for with clients who are complainants. So perhaps you could sort of talk a little bit about that, and in the context of Ontario, where at the moment there's no proposal on the table for reform.
Yeah, and I think, part of what Julie and Ifeoma are talking about, which is so important, is, and I'm going to borrow, actually, Anna, your metaphor that you used earlier, is, they're talking about changing the walls of the room, right? It's changing the legislative framework, changing the balance of power, changing the pieces that can be moved on, changing our default assumptions. And that is incredibly important. That's a huge part of what needs to happen and has been happening. I mean, you mentioned, Anna, earlier, even prior to the Me Too movement, but certainly through and after the Me Too movement. And that's a discussion about the third party, the public accountability, the other victims that could be affected. Equal and at the same time, as a practicing lawyer here in Ontario, I'm operating in the room that we are currently in. And so I listen to what Julie is saying and the myths that need to be busted, and absolutely that is part of, I feel, my responsibility. I have a responsibility to the complainant who comes to me to help them navigate the legal system that we are currently in. And so, and I'm happy to talk about this more, but part of what I'm trying to do is, on the one hand, certainly ensure that the kinds of agreements that my client might engage in are not unconscionable or not contrary to the public interest, but also helping them to identify what their own interests are, articulate what their own interests are, and then to advocate as best as I can for those interests. And so there's an individual at stake, and my job as a lawyer is to represent that individual to the best of my ability. And then there's the broader public interest, which is certainly of importance, and it's part of the equation. But my role as a lawyer is not to push my client to take a stance that they, for the purpose of public accountability, that they might not want to take. So, but I say that knowing, as Julie and Ifeoma point out, that those individuals are making those assessments in the context of an unbalanced legal system. So it's pushing on both fronts at the same time. I'm not sure if I'm really answering your question here, but it's so trying to keep paying attention to that broader public accountability and pushing that boundary, but also making sure that I'm actually serving the interests of the individual who's come to me for representation.
Yeah, and I think you're starting to pick up on the real tension. And I'm sure Julie and Ifeoma can jump in, but I really want to. So I started with the non-lawyer, and now I'm going to go to the man in the room, Dan, and a lawyer. So balances out.
Fair.
Yeah, but we are talking about changing perspectives potentially, and we're also talking about. From the employer's point of view, how much are they starting to see this as that the confidentiality is actually problematic for their reputation, or is it still the default is we're starting with a confidential agreement, really, or is that how you would approach it, and how have you found this in your practice?
Yeah, I will get to the idea that it's become a default, because I think there's some truth in that, Julie. To be fair, I'm a lawyer for employers, obviously, and I work both in prosecuting sexual misconduct, when there's discipline or discharge, and then defending institutions from allegations of failing survivors. So I see both sides, and tend to the conservative in supporting or let me say quite clearly that I'm hesitant when it comes to the idea of banning NDAs, not because of institutional or employer interests, but because I believe it would deprive survivors of agency and impede settlement. And I do want to kind of break down what's going on in one of these settlements. The potential is to take something that a prosecuting party in a discipline case can give to the alleged bad actor, to take that thing away from them. And the bad actor wants the NDA because it represents closure and finality of misconduct that is alleged but not yet proven. The settling employer does certainly, in settling a case, not even in giving the NDA, give up a means of making that misconduct public. And maybe this is a surprise, but for many employers who are principled, that is part of the calculus, is that we are actually giving up an opportunity to prove misconduct in a public forum, and that will have an effect on the public interest. But the costs of pursuing that public finding are high in many cases, and I'm not representing the witnesses to the misconduct in the same way that that Emma may, but I certainly need those witnesses to prove the case. I know from doing these cases that it takes a heck of a lot of extra preparation to get these witnesses ready and feeling strong enough to proceed. And I know from doing these cases that not all witnesses are up for it. So some employers will have that dialogue if it's a healthy relationship with the witnesses who are the victims of the misconduct or the survivor, and they'll make a calculated decision to settle a case. And it's very hard. Again, I'm not sure it certainly feels routine. Again, I'm going back to your point, Julie. But from a principal perspective, when you're negotiating with someone, it's very hard when you're not willing to prove the misconduct, to deprive them of the closure and the finality that's represented by that NDA that they want. So it becomes part of the agreement. It's very much a compromise, and I think the compromise feels bad. You know, that compromise is a byproduct of the experience that survivors face going through the civil justice process or testifying or something, in my view. I'd like to see different ways of solving the problem than banning the NDAs in light of that dynamic. I mean, you know, what do I think? You know, one thing is I think that we have to push on the law of unenforceability and make that clear. Emma and I talked before this. I don't think there's many cases. I'm not sure if you found one, Emma, but you know, the boundaries of what is and is not permissible, at least in our law in Canada, are quite unclear. It could be clearer. We need people to fight that and make it clear. I think that'd be a good thing. And then we just need to empower survivors so these processes are easier, in my view. Like if it wasn't so hard to go through the testimony, if the criminal justice system, frankly, was more open, because that's its job, to protect the public, we would see the NDAs in a different light, I think. That's the best way of describing my perspective on this tough issue.
Thanks, Daniel.
Anna,
And I think one of the things, yeah, sorry, go ahead, Ifeoma.
Mind if I jump in really quickly?
Yeah. Yes,
So,
absolutely.
two quick things that I want to say. First of all, the proposed bill in California would not ban NDAs. Non-disparagement agreements, non-disclosure agreements are totally acceptable in many scenarios. They just should never be permissible in cases of discrimination, harassment, or assault in the workplace. Because, and going to my second point, the burden should never be on survivors. The burden shouldn't be on survivors to push the bounds of what is permissible in court, because that's not a free process, whether financially or with their time or emotionally. And the burden shouldn't be on survivors to try to figure out the law themselves. Most people who are in a situation where they've been discriminated against or harassed in the workplace don't have access to you or to Emma or to an Anna. They're trying to figure out these documents on their own in a situation where they're in the middle of being pushed out of their job, and there is no ability to figure out, well, you know, if I go ahead and say something anyway, will they sue me? Here in the United States, it can be a totally frivolous lawsuit and still bankrupt you. And so the reason why I think it's important for the work that Julie is doing, for the work that I'm doing in changing the law itself around where you can use a non-disparagement or non-disclosure, is that if you don't, then that ambiguity allows individuals in the employment context to then intimidate folks into never sharing their stories. And then to an earlier point that was made, I don't remember who made it, NDAs are not really protecting an institution, they're protecting individuals. And I made this point, I wrote an op-ed that the New York Times published a few weeks back, where I laid out the case in the business context, and I won't speak to universities, but at least in the business context, the use of these NDAs protects individual executives at the companies and individual perpetrators at companies. Doesn't protect shareholders, because shareholders should be privy to what the culture is and the companies that they're investing in, and doesn't protect consumers, doesn't protect employees. And so we really are in this space where NDAs, folks can come up with reasons why NDAs should be used in the discrimination, harassment, and assault context, but what it boils down to is protecting people like Harvey Weinstein.
Right.
Fascinating. And yes, Julie, I want to come to you because I
Yeah.
think this is where it's, in some ways, you've just clarified some of the difficulties in the whistleblowing space.
Right.
But we're having difficulties with getting responsibility and accountability, which then leads to, when we don't, it sort of leads to a culture of impunity. And I feel like these two areas are overlapping and blurring, but they are distinct, and you've really clarified a distinct, or at least there's clarity in what you just said that I think is really worth pausing on. But yes, Julie, jump in, please.
Well, I agree with what, unsurprisingly, with what Ifeoma just laid out, but I just want to add a couple more pieces, kind of peeling back the onion here. And actually, there are a couple of things I'd really like to ask Dan and Emma directly, if that's kind of permissible, because I'm curious to know what they would say. Let me just briefly, first of all, mention I'm working on a bill with an Irish senator, Lynn Rowan. This was featured. We don't have a chat here, but I was going to drop it into the chat. This was in the Sunday Times this last weekend, and we're now on. I had a call with her this morning. We're on draft 4 of the bill. Like Ifeoma, I'm very optimistic that this can be a model. It actually is even broader again than the California legislation. It includes all forms of discrimination and harassment. There are 9 different heads of that under the Irish employment equality legislation. And it has a victim exception. But that victim exception is subject to not causing harm to others. And there's a number of different pieces of it, but another part of it, and this is what I wanted to actually ask Emma about directly, because this whole conversation, I find this really puzzling, always assumes that if you ask for confidentiality for a client who is the subject of the harassment, and there are reasons why people obviously would like to have that, there's always this assumption that the other side has to have it too. Now, I was a contracts professor for years, and I think we all know that when you negotiate an agreement, everybody doesn't get the same thing. Some people get one thing and some people get another thing, and there's a lot of trading off, and that's what negotiation is. And I've taught negotiation for almost 40 years too. That's what makes lawyers useful, because they can be good negotiators. And this idea that you can only protect the confidentiality of the victim if you also protect the confidentiality of the other party, whether that's the employer, the institution, the perpetrator, is nonsense. What it really comes down to is, again, this default assumption that if you're asking for it for your client, you've got to give it to the other side. And the Irish legislation, the draft bill, specifically says that it can only be to protect the identity of the victim. It is not to protect the identity of the perpetrator or the employer on the other side. So, Emma, I'd be really, and I've got a question for Dan if I'm allowed to ask it too, but I'd love to ask Emma what she thinks about that, because I find this really baffling that we always talk about this as if it has to be mutual.
So, I mean, I think that's a great question. And when I, again, picked up on Anna's metaphor of moving the walls around, I mean, that's a fundamental wall that most lawyers assume going into the mediation, and advise their clients going into the mediation that's going to be, they don't even think to advise their clients about it, because they just assume that is part of the room. So I think it's a fundamental question. I guess I have a couple of different answers, and Dan may also want to pick up on this. I mean, one of the first questions that I will talk to a complainant about when they come to talk to me, and once we've determined that there's a legal basis for a claim of some kind, is do do they want to talk about their case publicly, including who the perpetrator is, including what the allegations are? In some cases, they already have. In some cases, they've already engaged in social media posts and everything else. And in some cases, they really do. And so one of the things I say to them is, then you should do that. Go ahead and post, talk to the Toronto Star, not first of all, the Toronto Star is not interested in every case. It's a very Toronto metaphor here. But anyway, the newspaper's not interested in every case, but sometimes they are, particularly in the wake of Me Too. And so sometimes I say to them, before we ever get into a dynamic where anybody is pressuring you to give up your confidentiality, and we'll come to the question you're asking, Julie, in a moment, you should engage in that expression. And then that might affect the leverage that you have in a mediation. But if your interest is in being able to engage in that kind of public accountability, you should do it. And often we'll have multiple conversations about that and how they want to do that. And if they want to do that, and they go through different processing. So I think that that's a really important conversation personally to have at the outset, because that addresses in part what you're saying, Julie, about the confidentiality of the perpetrator. They've already now told their story. That name and those facts and those allegations are already out. They have to be careful about defamation, and that's also part of the conversation that you need to have as a lawyer. But I think that's really important, because that can, again, remove some of the pressure that they might ultimately face when they're in that mediation room. So then let's say we're in a mediation or in a settlement discussions, and there is, I think, an assumption on the part of the mediator, on the part of the lawyer representing the respondent, that the respondent is going to get confidentiality out of it, whether it's an employer or an individual respondent or both, because that is their main motivation in settling, right? In many cases, I would say they don't care particularly whether the survivor has confidentiality. If the survivor wants to go out and say, I've been sexually assaulted, okay, as long as you don't disclose to people the name of the respondent or identifying facts that would expose the respondent. So the employer, the respondent's interest, in a very pragmatic, practical, self-interested way, is their confidentiality. So we could push that, we could play chicken, and sometimes we do, and sometimes my client is going to say, I'm just not prepared to sign away my silence. And so let's say we're going to go to the Human Rights Tribunal and proceed with our hearing, or let's say we're going to proceed with our legal claim. But many survivors, at least who I've represented, at the end of the day, don't want to push it that far. And it may be because they don't want to deal with the trauma of the litigation, maybe because they have real financial need. And actually, a settlement is going to pay for couple of years of university tuition and a couple of years of rent.
But to be frank, Emma, your job is to protect your clients, and your job is to protect their interests. If that settlement, they need access to money without. And I mean, I'm not suggesting this is your practice, but I talk to a lot of people now who have signed NDAs, who have had lawyers representing them, and they talk about this as guns pointing at them from every side of the room. So their own lawyer, as well as the other side's lawyer, is telling them, you must sign this. And they don't even understand. And I mean, this is something that I feel strongly about, because I work, as you know, with self-represented people all the time. They don't understand that this isn't something that they have to give up in order to protect themselves. And I think that it's disingenuous for lawyers, and I'm not saying this is you, but for lawyers to present this as a take it or leave it. Either you agree to protect the other side's privacy and confidentiality, in other words, you let them loose on the rest of the world and you can't talk yourself, or you can't settle. And I mean, I'm sure you know that there are fashions in negotiation. I mean, I've mediated employment disputes, as I say, for decades. And if we told people, not being able to disclose the identity of the perpetrator, not being able to speak about what happened to you, not even if you go for another job, which is what happens all the time to people. They're asked, why did you leave that job? They're not allowed to say, because I was being sexually harassed. I mean, this is ludicrous, right? We don't have to accept that as the status quo. There could be different kinds of negotiations here. And I just want to remove the impression that as soon as you give confidentiality to the victim, you have to give it to the other side, because you don't, right?
Right. And so, and I'm going to throw this over to Dan in a second, but I think that what you're saying is exactly right in terms of making space for the complainant, the survivor, my client, to be able to make their own decisions and to remove that sense from them that there are a bunch of guns pointing at them, telling them that they have to sign, or that they're under some intense time pressure that they have to do it that day, or the mediation is over and then, the deal's going to be off the table. Having discussions with them about different kinds of confidentiality settlements. I've had a number of cases where the complainant doesn't particularly want to talk about their own individual facts, but they want to be able to engage in artistic expression. They want to be able to write a play, write a song, or many songs, many plays. They want to engage in public dialogue about a culture of sexual harassment, and they do not want to sign any kind of document that's going to prevent them from engaging in that kind of expression. And that, I think, is actually much more achievable now than it might have been 10 years ago, thanks to Me Too. I mean, that is something where you can push really hard and say, why should this person have to sign off their rights to talk about these issues broadly and their experiences broadly in order to get a settlement at the end of the day? Now, you're right to say, Julie, there is pressure on somebody to sign, if they want a settlement, to sign something that says that they will keep the confidentiality of the respondent's identity or identifying facts. That's absolutely true. And so I view my job as trying to kind of buffer and to hold back some of those pressures to give them space to make that decision. But that's a complicated dynamic for somebody to be in, including in particular if somebody has financial pressures on them or other realities of their life that they're also trying to deal with.
And I think actually this is why Ifeoma said, and I completely agree, that we need legislation, because I think the only way to take this off the table isn't to rely on individual lawyers, saying they won't do it. We have to take it off the table so it's simply not available to people. So instead of it being a great victory that somebody can in fact use artistic expression to talk about what happened to them, there simply isn't an issue about whether or not that their confidentiality has to depend upon the confidentiality given to the other side. Sorry, Anne.
No, I was just going to say, because you said exactly what I was sort of going to indicate. So the UK so far has done a solicitor's practice note with very good guidance, and solicitors do pay attention, but it doesn't take away that it's still up to the solicitors really to understand the limits. But at least it's clarified a number of these are improper uses of confidentiality. Again, there's room around that, but you can be held up for professional discipline if you are, and at least it's putting a break on what I think has been happening in the UK and in the City of London and sort of with the big law firms and everybody there's a lot of these settlements going on all the time and they're boilerplate. There's not a lot of thought about and really it's about money and money in those circumstances. But when we're talking about much more this disparity of power and victims of something, but also, victims not as in victimhood, but actually I suffered in this situation directly, doesn't mean I'm an all-out victim and that's the only way you look at me. And that's part of what we're trying to change, because silence, I think, and this is, I'd really appreciate all of your views, and Dan as well, silence is, might get you through the next bit, especially in these pressure cooker situations. But I've seen in the whistleblowing field, whistleblowers being very happy to start to talk about it, especially when they see that they have support and when they know it will make a difference. And they've a lot of people telling them, we're all here. We think this is important. And no employer at this point would sue you. But that's such, again, an unknown to people. So, Dan, I want to come back to you saying you don't really want legislation here, but what we're talking about maybe, is it something you'd be willing to reconsider?
Well, I'm thinking about it, obviously, thanks to everybody here. The idea that you could just take something and put it out of bounds for negotiation is interesting, and I kind of get that, right? If this is out of bounds, everybody remains equally able to resolve an issue despite the thing that's out of bounds. I think
Right.
that's what I'm hearing from you, Julie.
Yeah.
I just don't know if I mean I suppose I'm skeptical. Maybe I default to wanting empirical research or something. But if you're not going to be able to deliver true closure to the alleged bad actor, I'm just not sure you're going to get the buy-in to any deal. And again, I'm just making my argument over again, but I go back to the idea that we'll have cases where we have reluctant witnesses who are stuck in going forward, and I just think that could be quite ugly. So I'm thinking, but I'm not. Again, I'm more hesitant than I am a complete non-believer. I'll give everybody that. The one other
And
thing
can I
that
just ask you just one thing
Sure,
that you
Julie.
said, because it relates directly to this. I mean, I think first of all, you make a correct point that it's very difficult for people to testify. It's very difficult for witnesses to go through this. I actually had to testify as a victim in a criminal trial twice because the first trial was a hung jury. So I mean, you know, and even as a law professor, you know, that was not an easy thing to do. So I really do hear you on that. And on the university case that I've talked about, those students did not want to go through an arbitration, a grievance arbitration. But this is what I would challenge. You talked about, and I think I'm getting this right, in relation to workplace complaints, these are alleged but not proven. Well, what we're talking about here, for the most part, are workplace processes. Sometimes they involve unions, sometimes they don't, and they're formal grievance processes, but they are disciplinary and investigative processes. Now, believe me, they are, I know how flawed they are, but they do exist. And my colleague was written a letter of termination at the end of the investigation. So to say that that was not yet proven, I mean, we're not looking for workplaces to have, and you know this as well as I do, which is why you're grinning, to have a criminal level of proof here. It's not beyond a reasonable doubt. If somebody goes through an investigation and the investigator concludes, yup, it happened, then why is it that we think they should have so much power to walk away without anyone knowing about it?
Yeah, I mean, there's been a decision by the, you know, a unilateral decision by the employer to about the facts that make up the misconduct. I think.
But that's what
Emma,
happens in workplaces, right?
Yeah, but the grievance procedure is the forum for obtaining that justice under our labor law and collective agreements. I'm smiling because I'm looking at Emma, who would do the defenses on these cases, and I'm sure she would say that, right, Emma? Is that the due process is the arbitration process, I think, in the structure that is our structure is maybe my answer, Julia.
In a unionized environment where, I mean, Dan and I have argued against each other, with Dan representing the employer trying to terminate somebody and I'm representing the respondent, you know, not in sexual harassment cases, but in other types of employment cases. So we're used to making these arguments with each other, but certainly, you know, in a unionized environment, and Julie, you're very familiar with this, there's a standard of just cause that the employer has to meet. And so the fact that
and it's a very hard standard to meet. But let me ask you a different question then. What's wrong with saying that even someone who is alleged following an investigation, what is it that thinks that we have to protect them from the public knowing that they were alleged to have done this? I mean, I just don't understand why we keep saying we have to protect them and protect the employer. Like, why?
You know, your point that really resonates with me is the fact that it is a default and it is an expectation. It's an expectation amongst the survivor, the employer, the union, the arbitrator, mediator, right? And it's hard to break that expectation. The one thing that came to mind too, it's worth mentioning, is Elizabeth Wetlaufer. She, for those of you who don't know, she is a Canadian nurse, now a convicted serial killer who killed, I think, 8 people while in the employ of various nursing homes. And she was, I can use your term, Julie, she was the trash that got passed around from employer to employer. Right. And I understand that there was an inquiry, and maybe one of the findings of the inquiry was that these confidentiality clauses led to that phenomenon of a public threat being passed on and causing harm. My understanding is that public report, and I hadn't had a case. I don't do a lot of nursing cases, but just from kind of following along through email chains at my old firm, understand that many employers at that point were so shocked by that public report that they did take principled stands against that, and they viewed themselves as protectors of the public. That's an ethical position, I think, for an employer. I don't think it's a legal position. Obviously, they're not charged with a duty to protect the public, which is again why you're arguing for legislation. And I think I get the argument.
I think it's really interesting from a whistleblowing perspective. So I'll just jump in as because and this is where I was trying to position some of the thinking again to challenge us all. But if we stop thinking about some of these issues as private issues then they become public interest issues very, very quickly. And once they're public interest issues, then we have another responsibility in the room. And it's not just, it's not to run roughshod over the individual who is having to take on this position of challenging this whole system, right? If you're a whistleblower or you're a victim of harassment, you're not just taking on one person, you're taking on the whole system. And I think that one of the important outcomes of the Me Too movement and Black Lives Matter in particular. And Black Lives Matter, I think there's a sense that we've always known that racism is systemic, and yet we still, and this is where there's racism in the system, put it into an individualized. Individualized. Women are just realizing again, I just feel like the circle is coming back around, and we had a lot of these discussions and arguments 40 years ago, and we're reconnecting to them. And we had this weird 20-year hiatus when I've been a professional where we've lost sight of public interest and civil rights where we come together, and there's and unionization, all sorts of collective understanding of power. We're reconnecting that. And I think that this is where we're getting this coming back where I think it should be. Why aren't employers who are now delivering public services, private sector are delivering tons of public services, who are delivering public infrastructure, technology companies are delivering public infrastructure, we're all using them. Why don't they see it as the public interest is in that room too? And because they know about reputational damage, they're always thinking about the public perception. So anyway, I just throw that in there to the mix.
Can I just need to say, Anna, some do.
Yes. Sure.
I have a rosy view of all of my employer clients, but some do, but not all do, and the pressures go the other way, frankly. Yeah. So I'm all for having very socially responsible employers and organizations who care for the public interest and who think that way. I think that's wonderful. So just.
I know we have some questions and I haven't gone to them, but I just thought the conversation was so great, and Julie's been asking great questions already, and she may have some more, but I just wanted to go back to Ifeoma. What do you think of this discussion, and what do you think about the work you're doing, and where we can get the minds thinking outside of the assumptions and the defaults?
Yeah, so very specifically, all of the points that Dan, you're thinking through, I refuted, I think, persuasively in the op-ed that I wrote. But then also, you asked for empirical evidence. We actually have that in California. 2 years ago in 2019, there was a law passed that only pertained to gender-based harassment and discrimination in the workplace. Since then, we've seen no reduction in settlement amounts, no reduction in settlements, because when you just take it out of the conversation, then it is no longer something that you negotiate further. And I made this point, and it's a point that I didn't realize was new to so many people in the New York Times piece. At least in the United States, what the employer is paying for in a settlement or a severance is the release of claims. That may be different in Canada, but what you are paying for is to not be sued again or not to be sued in the future. You don't actually need to pay for the silence portion for the rest of someone's life if you're not going to be sued. And if someone lies, you can still sue them, at least in the United States, for defamation. And so there are so many mechanisms and tools and triggers that employers still have. So holding on to forcing people to be silent for the rest of their lives, and at least the way that the agreements are written here in the United States, in every context, so you don't need to go to the New York Times for your employer to have the ability to come after you. You can talk to family members about it, and that's breaching your agreement. You can explain in an interview why you left your job abruptly in the middle of a pandemic, and that be breaching your agreement. And at least here in the United States, it's not just, oh, can you afford to participate in artistic expression or whatever else in the future? Health insurance is tied to these agreements in the United States. So you literally lose your insurance on the day that you sign the agreement often, or don't sign the agreement if you don't. And that is part of the bargaining as well. And so the stakes could not be higher when it comes to people, their lives and their families' lives. If your whole family is on your insurance plan and you're having to make this decision in the middle of a pandemic. So that's why I think it's important for the law to remove those instances at least from the discussion. Outside of that, if you lie, your employer should sue you. If you break other parts of the agreement, like you start sharing IP, yes, they should come after you. Right. But talking about an experience of discrimination, which is already against the law, that there's no defense for keeping that in agreements.
And Ifeoma, can I just ask you, because this was the point that Dan made, a lot of the time this hasn't gone through a criminal process. It hasn't gone through a civil process. It's a workplace process. But is there any more reason to keep it secret if it's just alleged? I just don't understand that.
I don't see it. Again, if you lie, if that can be proved, that is an easy defamation case. And any employer should go after folks who lie about their experiences. The reason why employers aren't is because they also have the evidence that many of the allegations that are made are true. And as someone who has spoken up about my own experience, I would have liked to have never had the experience to then have something to speak about. This is not something that people do for fun. You don't talk about something that you've experienced because it's fun or because there's any part of it where you're gaining anything. And so I don't think anyone should be forced to speak up about what happens to them for anyone else. I don't think it's any victim's responsibility to speak up in the public interest, but you should retain the right to, if you choose to, in any way that you choose to going forward. And signing an agreement where you work somewhere for 2 years, for 50 years, that is over your head until you die is, at least here in the United States, I think fundamentally un-American. And from what I know of Canada, it's un-Canadian as well.
And just FYI, the Irish legislation makes all confidentiality agreements that victims sign waivable. Like, why the heck not? They can change their mind. They often do, just as Anna said about whistleblowers.
Okay, should we open it up to the audience? We have a few more minutes. We can definitely keep going, so I don't have any doubt that there's a conversation to be had. But Ange, do we have some questions? And if anyone in the audience, if you haven't thought about it because you've been enthralled or overwhelmed, but have a question, please put it in the Q&A and Ange will pick it up.
Hi, yes, yeah, and a reminder, as Anna said, to please use the Q&A button if you have a question for the panel. The first question is from Leona, and Leona asks, could Emma and Dan please indicate what they feel is the most important change, if any, in legislation that could deal with the issues discussed in this panel today?
So the question is what the most important change we could achieve through the legislation, through legislative change?
Yeah, what change would you want to make?
Well, I think that Ifeoma has just articulated that so powerfully throughout. Julie too, but Ifeoma just as a non-lawyer to be explaining, from the perspective of somebody who, and I don't know all the ins and outs of the tech world in particular, but being required to sign agreements from before you even entered into an employment relationship that then have these coercive confidentiality requirements. I think to have legislation which regulates the context in which confidentiality can be offered or asked, and there are different iterations of that, I think is very powerful at resetting the power imbalance. So I don't want to repeat everything that Ifeoma has said, but I think it's a really important model.
Dan, do you want to respond?
Yeah, no, I'm listening. I like that there's statistics out there, Ifeoma. I'll look them up and I'll keep thinking. So thank you for that. I'm conservative maybe as a function of my privilege, right? When I thought about what a legislative solution would look like, I tend to gravitate towards a more conservative solution that would involve prescribing or limiting certain types of overreaching that, when I hear about the type of overreaching that you're talking about, Ifeoma, I kind of just am shocked. And the Weinstein one that came up about, you can't talk to your doctor without causing your doctor to sign an NDA. It's,
But Dan, I see agreements that do include these kinds of clauses, and I'm talking now and in Canada.
Oh, yeah,
the one about not talking to a therapist, that comes up all the time. You can't talk to your therapist. So
ban that is the starting point for the conservative thinker, right? And I'm just kind of throwing up an option that would be less restrictive and would allow kind of the ins and outs of the settlement dynamic that I tried to explain.
Okay, well, and I would just challenge a little bit your use of the word conservative, just because I think I feel like what we've had is a creep of all the ways in which confidentiality has crept in. And partly to do with technology and partly to do with the information age, but partly to do with, again, what I think is the decollectivization, the other powers that used to exist. Now, I'm not saying anything was perfect in the past, but I feel like this has been coming in not just quietly anymore at a kind of hyper rate in the last 10 years where it doesn't even make sense to me. It's like we're supposed to just be grateful for good salaries and stay silent if we happen to be in industries with good salaries, and then it creeps down to people who are working in industries where there isn't good salaries, and it's just the normal way of acting. So I just want to challenge a small c conservative, because I think actually that ground has changed too, and it's to hold on to some of that is actually maybe not the right starting point. It's actually to look at what the point of these agreements are really meant to achieve as a lawyer, and in all the interests that we're meant to take into account when we're advising our clients, including the public interest, which is a lawyer has some duties towards as well.
I think also conservative is an interesting word to use, because conservative to conserve power for the employers where the power already exists. Yeah. That's the goal of being conservative. And then the original little c conservative, at least in the United States, would be on the side of preserving freedom of speech. So
I also just jump in to highlight or sort of underscore something that Ifeoma said earlier about the idea of not having legislation, but leaving it to the survivor to address through the unconscionability doctrine, which is something that a number of people have, a number of kind of legal observers and so forth have suggested. I just kind of want to underscore what Ifeoma already said, which is that that puts such a burden on the complainant, and in Canada also, where you not only bear the legal costs if your legal action is unsuccessful, you bear your own legal costs, but you also bear the legal costs of the other side. That's just a huge risk that most people are never going to be able to undertake. So I think in my mind, I'm not sure, there's different forms of legislation, there's different models that we could talk about in debate, but I don't think that leaving it to judicial scrutiny and courts and individual legal action is the answer.
I completely agree, Emma. I mean, I think, I've seen some obviously duressed agreements, obviously. People being told they have to decide, they have to sign right now. I mean, we know that in theory, all of these things are challengeable in a court of law. But to say to that same person, now you have to go and bring an application, I mean, that's absolutely not the right way to do it. I agree with you completely. That's why there needs to be legislation to take it off the table.
Can I see if there's another interesting question there? There are, I'm sure. And
Yeah, the next question, somebody asked, do you find that NDAs in the context of sexual assault are close to being a violation of ethics, of implying that the victim will not report the sexual assault to the police?
so I'm going to jump in really quickly under it would be, and this is what the solicitor's practice says, is definitely a disciplinary offense. If it's about anything criminal, you're not allowed to sign it. You're absolutely not allowed to enforce any kind of gagging clause on someone where it's about an illegal act. And so that would definitely be something that would be unconscionable and would be illegal. And I think, but that's just, again, that's not saying it's not tried, but under
and the other difficulty,
well.
of course, we have in Canada at the moment is that sexual harassment is not generally a crime. I mean, it's not part of the criminal code. So, you know, you miss all of that stuff right away. But certainly for a rape or something that we know is part of the criminal code, but there's an awful lot of this behavior and also discriminatory and bullying behavior, which is not yet part of our criminal code. So it wouldn't help that.
Yeah, I think that the UK code with respect to professional responsibility of lawyers would be really, really worth exploring here in Canada and in Ontario, because you know, one of the commentary that I was reading about the UK code points out that it helps give lawyers guidance, but it also helps lawyers to be able to address those situations where the public interest and the interests of their client might otherwise be in tension, because you're not allowed to engage in those types of agreements. So I think that would be a really valuable area to be addressing. I also think, and Dan might have something to say about this, but you know, in Ontario, under the Occupational Health and Safety Act, under the Human Rights Code, employers have an obligation, separate and apart from any settlement that might be some private settlement that is negotiated. They have an obligation under the Human Rights Code to address discrimination that's brought to their attention, to address harassment that's brought to their attention. Same with under the Occupational Health and Safety Act. And I've been in settlement discussions where the union wants to negotiate a settlement that will end an investigation, and the employer says, we are not allowed under the Occupational Health and Safety Act because we have a statutory duty to continue with this investigation. So I'm not sure that you actually could, Dan, you know, that an employer could say, well, we're just going to negotiate a settlement and then not address this assault that has occurred in our workplace.
But it does happen.
Except if you're passing, and I'm just being blunt about it, except if you're passing the trash, right? Like, this is your obligation as an employer is to your workplace, right? And quite often when you have you know, a problem with student witnesses, for example, who you don't want to parade before an arbitrator and run them through all that, the easiest way to solve your safety problem in your workplace is to reach that deal. Right.
Exactly.
So there is a safety duty that goes to a public, but it's a public within a sphere, which leads to the you know, this issue. So.
And of course, what we're starting to see as well, I'm sure you're aware of this, Dan, from your area of practice, is students becoming more organized on university campuses, both in the US and in Canada, and beginning to bring suits against universities for failing to protect them from known or acknowledged, let's not say proven, known or acknowledged perpetrators. And I think that that's also, I think that employers need to get hold of the idea that they might think that they're escaping consequences, but they're probably walking into a whole bunch of other consequences too. I mean, it just doesn't make sense to me.
It is a different way of viewing legal liability and how far that actually goes. And it is beyond the workplace. And whistleblowing, again, as it's classically defined, is kind of easier. It shouldn't be. Like this discussion is being really, really helpful for me too, about, you know, we really have to keep our eyes and ears, but eyes on what the public interest means. And yes, there's some haziness, of course, because it has to evolve and and the haziness is not bad. It's called flexibility and adapting to new potential risks that we didn't know we had. COVID might be one of them. Some of the technological risks that we take and safety, you know, we're having these debates. And I think it's so interesting that Ifeoma her situation, even though that's not what the NDA Farm Bill is all about, is in an industry that has been able to develop so fast and make all the mistakes that every other industry has ever made, all in one. And it's not about industrial safety risks. But it's a different form of toxicity. And so I do think that lawyers need to be reviewing what the law really means when it says public interest and be on top of that. And this is a field that is evolving really rapidly.
But in some ways, Anna, I mean, I agree with Emma that the Solicitors Regulation Authority guidelines in England are very exciting. I mean, I was very excited when they first came out. And I thought a lot about, how far should we be trying to press the law societies whom I work with here, because of my work with self-represented litigants, to do that. But I'm also not sure that it's fair to make this the responsibility of every individual lawyer to interpret what that means. And once again, legislation simply takes it off the table.
Sure. And there's both, right? Because it's, we're really privileged people, and we have to take responsibility. I think it's about our accountability. It is part of my accountability as a lawyer, and I might get it wrong sometimes, and I should be held to account. Doesn't mean it. All it says is it may be subject to a disciplinary offense, which probably means I do it all the bloody time and I don't learn.
Yeah, there have been some failed attempts to discipline people already, Anna, I can tell you. So,
oh, absolutely.
But also, on behalf of self-represented people without lawyers, it's not going to help them that there's this solicitor's guidance. It has to be legislated.
To me, Ifeoma.
Wouldn't the guidance then in that case for a self-represented individual be for the lawyer of the employer?
Yes, it would. Yes, it would. So it would make that amount of difference. You're right about that. Yeah.
I can just read really briefly. I won't read the whole thing, but it says we consider, so it's the solicitor's professional authority talking to its lawyers, right? So this is another form of accountability for professionals. We consider that NDAs would be improperly used if you sought to use it to prevent or seek to impede or deter a person from cooperating with a criminal investigation or prosecution, reporting an offense to a law enforcement agency, reporting misconduct, serious breach, or making an equivalent report to any other body for supervising or regulating the matters, for making a protected disclosure under the Public Interest Disclosure Act. So it really is saying you have to be thinking all the time, and you have to be really challenging your legal responsibilities here. And, and you want to give good, solid advice, and some of that's based on past practice, but you have to be looking at what's really happening and keep on top of it. It's one tool.
And Ifeoma, of course, if you're a self-represented person up against a lawyer on the other side, they're not going to tell you about this. So, go figure.
Exactly. Where I see the benefit, and I actually thought about this in my case, the General Counsel of Pinterest was retaliating against me directly. I can't file an ethics complaint against her because we don't have a public interest law in California that guides her behavior as a barred attorney in the state. So that in the United States, at least, we need first the public interest protections that don't exist, and then to be looking at the lawyers who are writing these agreements.
Ange, do we have time for one more question?
Yeah. Okay, the next question, somebody asked, it was mentioned several times during the conversation that NDAs potentially protect the perpetrator. Is there an assumption that the perpetrator does not have a right to a certain degree of confidentiality, considering one, despite public interest argument, information is usually not relevant to 99.9% of the public who would learn personal data of the perpetrator? And two, there is a concern that the perpetrator or company can become subject of an unfair public judgment before conclusions are made.
There's
I
a
think
lot
I
in there.
answered that with the defamation bit. If you should have no issue if the person is telling the truth, and if they are telling the truth or the lies can be proved that they've told, then sue them for defamation. That's it.
Right. Or unfortunately, if you have an NDA that's hiding the truth, you can be sued, as I know, successfully for defamation. But I think that question is interesting because it brings us back, I think that's an interesting question to, this whole due process idea that Dan and Emma were talking about earlier on. If you haven't actually gone through a formal legal proceeding, but you've gone through a workplace process, even part of a grievance process, but you haven't been in a court, either criminal or civil. I mean, I would still say that, this is bringing us back to where we began in a way. We have become so obsessed with the idea that everything needs to be hidden. I don't really understand why it isn't relevant and important that even if somebody hasn't been, proven guilty in a court of law, that a history, because in these cases, believe me, these are not one-off complaints. I mean, by the time you get somebody investigated in a workplace, they have been doing it for years. I mean, you've got to believe me. And that certainly applies in universities as well as other workplaces. So what is wrong with another employer? I mean, there aren't going to be members of the public randomly who want to read about this, but what's wrong with another employer knowing that they have had all these complaints against them? One of the features of the non-disclosure agreement that the University of Windsor gave to my former colleague was to completely erase all the complaints. This was explicitly in the agreement that had been made against him in the past in his personnel record. I mean, I just don't think that's right. Because that is information that the next employer needs to know in order to keep their own safety obligations towards their employees.
I think this is probably a really important place to end, but also to re-emphasize, because I think that there's an assumption at the beginning of everything that we have to protect, oddly, someone who may be accused, and we get confused about where the steps in the process that do balance out the interests, and we're already somewhere by the time we're in this negotiation. And again, what we've talked about is taking certain things out of the equation so the negotiation can still happen. And it's not like there's no role for some form of confidentiality in some of these agreements, but we have to be really clear. And, we can explain these again, right? So some of that question was a little bit some of the information that we've walked through, but we need to get our heads through it and be continuously re-explain. I do think lawyers really need to take the time to keep questioning, because I do find my own strange defaults coming up again. I have to remind myself, and I do in whistleblowing all the time. And even in 20 years of doing whistleblowing practice, I have whistleblowers explaining to me how I still get it wrong. We need to be open to critical assessment of what we're doing, and it can get quite easy to get used to the walls and the paint. We walk into a room, we get, and we're going to help people with this little messy business of where the chairs and the desk go, but we're not really looking at the structure. And when we're talking about power and balance and power, we need to keep reviewing the structure, because they put a tower on it and another wall, and you don't even notice, and you're in another building. Anyway, that's enough for my architecture and COVID-related house house changes. But thank you all so much. What a enlightening conversation, and looking at it from very, very many perspectives, all of which have to be addressed and heard and challenged and discussed. So yeah, thank you all. I think we're out of time. I will hand it back to our organizers, because I don't remember what they said about actually signing off. But yeah.
Thank you, everybody.
Oh, Jim arrived and left.
For some reason, my computer removed me as soon as I entered. I want to join Anna in thanking the four panelists for a very engaging discussion of some complicated and difficult issues. And I want to thank the audience for participating in this, listening to it, and to let you know that a recording of this, video podcast of this, will be put up on our website tomorrow. The website address is cfe.ryerson.ca. And as well, we're going to put up some additional resources and readings for anyone who would like to dig a little bit further into the issue of confidentiality agreements. I also would like to let you know about the next event in our series of panel discussions. It will be occurring next week, a week today, on Wednesday, May 5th at 4 p.m. Eastern Time in Canada. And the title of it is Pressured to be Silent: Workers, COVID, and the Cost for Society. Throughout this pandemic, There have been epicenters in long-term care homes initially, and now workplaces of various kinds, and warehouses and factories and farms, where largely the workers have been rendered silent about what is happening to them and their communities at a risk of losing their jobs or their pay, which is necessary to them and their families. The panel for this topic is going to look at and discuss what's happened, what's it meant for workers in society, and what could be done to help make sure that people have the right to speak up without losing their jobs or suffering other penalties. So I hope you'll join us next Wednesday at 4 p.m. Eastern Time for that discussion. And also would like to tell you about a series that will be beginning on May 19th. It's going to be a series of conversations about taming big tech. What do we do about the spreading disinformation and false narratives and misinformation that is so prevalent and so difficult as governments wrestle with this question? Nobody has so far come up with really clear options that don't raise as many problems as they may solve. And our first conversation is going to be with quite a noted American writer and tech expert, Cory Doctorow. So that'll be on May 19th. For more information about any of our upcoming events and for podcasts of all our previous events, again, go to our website, cfe.ryerson.ca, and click on events. Thank you very much for joining us today. Bye-bye.